Okay, and then looking at the proposed extension, so initially the proposed extension up to £25,000, how as a practitioner do you see that working in practice?
Large amounts of the protocol can remain the same. However, there are very important and significant differences, in my view, required, and they are broadly around medical evidence, the provision of other evidence, for instance, care report, and also the provision of interim payments being inadequate for larger value cases, and lastly the provision of witness evidence, because if you get more serious injuries, and the new bracket will engage post-traumatic stress disorder, minor psychiatric injury, some more complicated spinal conditions and so on. And so in my view, it's essential, if people are to be properly compensated, that they need to have a witness evidence with regard to quantum, which needs to be before the court to evaluate what should be awarded. So those are some of the areas that need to be looked at and amended for the increased remit.
And if they were, do you think that it would work, or do you still feel uncomfortable that actually once you get over £10,000 these claims are quite complex and none of them can be regimented or formulated, and therefore they shouldn't form part of a portal?
I'd say two things. One, that we have to remember that to be dealt with in the portal, there's got to be an admission of liability, so we're just looking at quantum. And that brings me to the second point, which is my concern would be to make sure that the court had all the evidence it needed to make a proper evaluation. In my view, that is possible and achievable by amendments to the rules. What I wouldn't support is using the existing framework for much more serious cases.